Okay, let's hear the cross from the prosecution now.
Good morning, Officer Jang. Just a few follow-up questions for you. In the video we just watched, at one point when you were talking with Officer Tao, it sounded to me like you asked him still red.
Yes.
What is that? What you said?
Yes.
What does that mean?
If his body camera is still on.
And so you were asking him if his was on?
Yeah.
And that's because you had yours on still.
Yes.
Was he asking him, or was he telling him that his was red?
So, Officer Chang, when you're working for the Minneapolis Park Police, you go through the academy with city police recruits, correct?
Yes.
And at that point, when you're going through the academy, do you know whether you're going to end up in the park police or the city police?
When you first start the academy, you already know who. Sorry, you already know who you're, I guess, working for. This.
So, as far as you know, those recruits, you could be working with them someday in the future.
I guess on a straight. I mean, if we patrol the same area or precinct does. But.
Right, but when you start, you could end up being a city officer just like them.
No.
Okay.
So when you first start, I guess you already get the offer from the employer. So you received the offer from Minneapolis Park Police prior to starting the academy.
Okay, now I got it. So when you're in the academy, you know you're going to be park police and the others may be city police.
Yes.
All right. But when you get out there on the streets, while you monitor the parks, you also have authority to assist with calls outside the parks.
Yes.
So in terms of an average shift, let's say, how often do you do this where you assist on a city police call?
Not often, unless we're close by. Unless we don't, I guess there's no calls at the parks, but we pretty much keep ourselves busy with the park system.
But if you self-assign to help a city call, you're not going to get in trouble from your supervisor for that.
No.
Because that's all part of your responsibilities. You're allowed to do that.
Yes.
And in fact, when you're doing that, when you're working in the park police, you have the same
That's a nice knot on that tie.
radio traffic. You're able to hear the same radio traffic as the city police officers.
Yes.
And in fact, I think we heard you refer to the city officers here as your partners, correct?
Yes.
So when you're there, you look to them as your partners in working the scene.
Yes.
And you would suspect that they feel the same way about you, I assume.
Yes.
Okay. And with this particular call, you heard a request for backup, right, on this call?
Yes.
And because you heard some noise in the background, you decided initially to go lights and sirens.
Yes.
And to self-assign, I think was the term you used.
Yes.
Okay. And at some point, though, on your way there, you turned off your lights and sirens, right?
Yes.
Okay. And that was before you actually arrived.
Yes.
And when you arrived, I think we even heard, as you're pulling up, the officers already assigned call code 4, correct?
Yes.
And what is your understanding, or back on May 25th of 2020, what was your understanding about what code 4 means?
Scene safety.
So it's under control, correct?
Yes.
All right. And when
Oh, I didn't know that. I heard that code 4, but I didn't know who said it, so I didn't assume that it was these officers on this call. But evidently, they did go code 4, which I'm not sure why they would go code 4 when you're fighting with a dude. You never go. Maybe they went code 4 when they got him at the vehicle and he was in handcuffs, and they're like, okay, we're going to put him in a car. Let's stop other units. We'll go code 4. So I'd like to know at what point in the fight were they code 4, because if it's once they hooked him up and was walking, I understand. If it's when they had the guy on the ground and they're kneeling on him and they went code 4, I wouldn't understand that.
When you got there, you got out of your squad car, correct?
Yes.
And you see 2 city officers,
Yes.
and one who you later find out is Officer King.
Yes.
See, this guy to me, why he's a good DA, is he's not confrontational. He's not trying to argue with the defendant. He's asking questions in a reasonable manner and soliciting kind of reasonable responses. And that's, some people are going to say, why do you like him? You don't like the other guy? I just, his demeanor and the way he answered questions, to me, he's courtroom friendly. He's jury friendly. He's witness friendly. He's not the adversary and the normal DA, I'm in charge ego. He just seems like he's doing his job in a good way.
Speaking with Mr. Floyd.
Yes.
And Mr. Floyd is sitting on the sidewalk against the dragon walk.
Yes.
He doesn't appear to be threatening in any way at that time, does he?
No.
Doesn't appear to be agitated or upset in any way at that time.
No.
So right there sitting on the sidewalk, he was pretty peaceful.
Yes.
And when that happened, you never heard the officers call for a code 3 to other officers responding.
No.
So they did not call a code 3, correct?
No.
That's we're doing this question thing. You heard later there was a call for code 3 on the ambulance, the EMS, correct?
Yes.
But there was never a call for code 3 for the responding officers.
I don't believe so, no.
And when you arrived and got out, assume you were trained to assess the situation, correct?
Yes.
And you did that as you're getting out of your squad car?
Yes.
And when you did that, did you hear Officer King ask Mr. Floyd for his name?
I did, yes.
And you heard Mr. Floyd give his full name,
Yes.
spell it,
Yes.
and his date of birth?
I believe so, yes.
And then you were asked to run that through your system, and you were able to do that, correct?
Yes.
So,
This guy on the Park Police is getting so much shit from them. Like, dude, the one call you decide to back up turns into a national freaking riot fest and crazy incident, and you're going to testify in the freaking trial and be on TV. And
then you observed as the officers, Lane and King, walked Mr. Floyd over to their squad car, correct?
Yes.
And that's when you decided to move your squad car over to that area, correct?
Yes.
And your intention there was to help those two officers with what they were doing.
Correct.
But as soon as you got out, they asked you to go watch the scene by the Dragon Walk with the two passengers.
Yes.
And you did that. You then walked back over to that location.
Yes.
And once you walked back over there, you really couldn't see what was going on with Officers Lane and King and Mr. Floyd in front of the cup foods.
I believe at that time they were still, still had Floyd against the car. I believe during that time, yes.
Okay, so again,
see, the defense needs to come back on when they told you to go over there and watch the other people. That's because they didn't have enough officers and they had an insecure evidence and a crime scene that they weren't secured, and they had two other people that they had their IDs. So they wanted you to go do that. Otherwise, if that wasn't the case, they would have probably wanted you to stay and help. And I don't know how he would get that across. But the only reason those officers sent him away is because they're in the middle of evaluating everything else that's going on. The crowd, George Floyd line, resistance, fighting, all that. They're like, shit, we still got a crime scene over there that's not even secured. Great, we got another body. Go help them. Because they didn't know that Floyd was going to kick his way out of the car or fight when he got in the car, and they would end up pulling him out. That's why they sent him away.
against the driver's side of their squad car.
I believe so, yes.
But once you walked over to the far side of the road, over by the Dragon Walk, you could no longer see what was going on with Mr. Floyd.
Yeah, yes.
You indicated that the crowd was getting louder and more aggressive, correct?
Yes.
And but you knew that there were now 4 officers over at that scene, correct?
Correct, yes.
And so your main focus was on watching those passengers.
Yes, in the car.
And you assumed when you were doing that that those 4 officers were okay over there because there were 4 of them, correct?
Yes.
And if they had radioed for help, you would have heard it over your radio.
Yes.
And they never radioed for help, did they?
No.
I have no further questions, Your Honor.
Anything further?
I don't think he helped either one of them other than getting his video in.
Thank you. You're excused. Thank you. Members of the jury, we're going to take a 10-minute break while we check the availability of the next witness. It'll probably be our last break before...
The defense recalls Officer Nicole McKenzie.
Recalls Nicole. Oh. That means the defense already called them. Or the prosecution called them. And now they're recalling them.
And let's have you state and spell your full name again so the court reporter has it.
So, Nicole, Nicole, last name McKenzie, Mackenzie.
Oh, I liked her. I thought she was a good witness. I'm glad he called her back.
Okay, Mr. Nelson.
Thank you. Good morning, Ms. McKenzie.
Morning.
Awesome.
Officer, I apologize. I'm sorry. You've previously testified in this case, correct?
I have.
And just to refresh the jury's recollection, what is your role again with the Minneapolis Police Department?
I'm the medical support coordinator for the department.
Okay. And in terms of...
Can you take your mask off?
Yes, sir.
Okay.
Thank you. In terms of the training that you provide to officers, fair to say that the training consists of both academy training and veteran officer training called in-service?
Yes, sir.
And in terms of the training that your department provides, does your department provide excited delirium training to officers in the academy?
In the academy, yes.
And that's not something that routinely is given to the veteran officers?
Correct.
All right. Now, you understand that Officer Lane, who is a part of this case, recently attended the academy.
Correct, yes.
And he would have seen the materials that the Minneapolis Police Department provided.
Oh, you see where he's going here? See, I'm always trying to figure out where they're going. He's saying because Chauvin was an experienced 19-year officer, he didn't get the excited delirium training in the academy. And he may not have gotten it in his reoccurring training. So when the younger, new officer, inexperienced officer mentioned we should roll him over, the younger officer was reacting to his training that he just went through. But Chauvin wasn't aware of that training. He didn't know that that was a new training, and that's why he said, no, leave him here. That's a good point.
Relevant to excited delirium.
Yes, sir.
And you've had an opportunity and you've reviewed the PowerPoint presentations that are prepared in that regard.
I have.
Do you mind if I start?
Members of the jury, you're about to receive evidence regarding excited delirium training that was received.
Why is it every one of his witnesses, they have to address the jury about what they're going to hear? And I didn't hear him do that once on the prosecution case.
By Officer Lane at the police academy. This is being offered for the limited purpose of explaining why he used the phrase excited delirium on May 25th, 2020, and what that meant to him. This is not being offered as state of mind or knowledge of the defendant, since we have no indication in the record that this defendant, Mr. Chauvin, took this training. So accept it only for that limited purpose regarding Officer Lane. Mr. Nelson.
Thank you. Just going to show you, this has been pre-marked as Exhibit 1053. Does this appear to be the training materials the Minneapolis Police Department provides for officers, cadets in the academy?
It does.
Does it? And just skipping through, does this appear to be a accurate copy of that?
It appears to be so.
And I'll just kind of scan through fast. To be pretty much the entirety of that training?
It looks like it, yes. Certainly. It's a condition that's a combination of a variety of different medical issues that are happening at the same time. This could be something like psychosis, agitated delirium. It could be pressurized speech, incoherence.
She almost seems more nervous than she did last time. I'm wondering if she got called in. I guarantee you, anytime the defense calls you, I've been called by the defense a couple times. Anytime the defense calls you, you have to deal with the comments of, oh, you're testifying for the enemy. Oh, you're trying to help them. Why are they calling you? You must going to help them. Oh, are you a traitor? Are you going to sell out the department? Are you not a team player? So you get all this freaking outside interference, threats, comments, and maybe that's why she's acting. Because I guarantee you, she got shit saying, oh, you must have said something the defense liked if they're calling you back. What are you? Are you sleeping with him? Why is he calling you? What do you have a connection? Why are you trying to help him? All that shit happens behind the scenes.
Speech, superhuman strength, hyperthermia. They could all be present.
And does the Minneapolis Police Department train cadets, what types of things cause excited delirium?
In a general sense, yes. It's a combination of pre-existing factors. It could be cardiovascular disease, also illicit drug use, and also mental health diagnoses.
Okay. And in terms of the signs that officers are trained to look for, could you describe what those are?
Yeah, we do use an acronym to correlate with that, and we use the acronym of not a crime. So there's a varying different things you might see if somebody's presenting with excited delirium. Like the person, because they are experiencing hyperthermia, meaning excessive temperature, they might be removing their clothing, they might be speaking incoherently. Whether it's a bystander or the caller, they might describe the person had just snapped. And if I could reference my materials, I can go through a little more in detail.
So for purposes and subject to the state's objection, the defense moves to introduce Exhibit 1053.
Subject to the court's rulings, 1053 is received.
You see the first letter of your acronym, not a crime, before you.
Yes.
And what does that stand for?
The patient might present as naked or sweating, removing their clothing.
Okay. And the second slide being, or excuse me, the next letter being O?
Yes, and that's objects, exhibiting violence towards objects.
Okay. T?
Is tough and unstoppable.
And that's what you described as like superhuman strength?
Yes, sir.
A?
The onset is acute.
What does that mean?
And that's where somebody will say the patient just snapped.
So it's rapid or fast?
Right.
C?
The patient is confused. Might be speaking incoherently.
R?
Resistant.
And define that?
That the person will likely not be able to, they don't have the capability about them to respond to commands to comply.
Okay. And I?
Incoherent.
And how would you define incoherent in this sense?
If somebody's like experiencing some level of psychosis, they might be talking about complete nonsense. Their words just don't even make sense, and there's really no dialogue you can have with them, meaningful dialogue you can have with a person.
Okay. And M?
That'd be mental health. The person or callers have some kind of information that leads to believe there's some mental health issues going on.
Okay. And E?
And that EMS should be requested early.
It's fair to say that if an officer suspects excited delirium,
If you're teaching this and you don't know and you have to look at it, how do you expect officers to sit out there and go, not a crime, in, non, was in, yeah, I'll do that in the middle of a scene while I'm fighting with somebody. That's government bureaucracy ignorance.
Delirium as occurring with a suspect. There are certain steps that they are encouraged to do, correct?
Correct.
Can you define what an officer should do if they encounter a suspect they suspect is suffering from excited delirium?
Definitely get more resources started, because you might need more resources than you would think. And then also having EMS stage at a safe distance away until the situation is under control.
And obviously attempt to control the subject
Correct.
through physical restraint.
Yes.
It's fair to say that once a person is in handcuffs under the excited delirium, you train officers to put that suspect in the recovery position, agreed?
Correct.
And what would be the purpose of bringing EMS on scene?
Because people that are experiencing the excited delirium syndrome, they can rapidly go into cardiac arrest.
To train Minneapolis police cadets, correct?
Correct.
Now, again, as far as veteran officers, they may not see this particular training materials, correct?
They would not.
But is excited delirium a subject that is discussed in in-service trainings generally?
It has been in the past, but that was not with the medical support team.
So in terms of use of force or other questions? Or other areas of training?
Correct.
Okay. Your Honor, I have no further questions.
Mr. Frank.
Wow, I thought he would get more out of her. I can't remember her testimony, but I thought she was a really good witness for him. And again, she's honest. She doesn't feel like she has one side or the other. She's just answering the questions. That's why I think she's a good witness. Now, the prosecution is gonna, she better get ready, because they're gonna really try to turn her. Unless it's the guy that I like, he's pretty fair. If they put that crazy woman, chicken on crack woman up here. All right, so they got this guy. It'll be pretty civil.
Thank you, Your Honor. Officer McKenzie, I have just a few follow-up questions for you. So the basic training on excited delirium with cadets or recruits is what to look for,
Correct.
and then secondly, what things they can do.
Correct.
And one of the things that they are told to do is to put the person in the side recovery position, correct?
That is correct.
And that's to help facilitate breathing,
Yes.
because excited delirium, if it exists, could compromise proper breathing.
Absolutely, yes.
And officers, both in the academy and veteran officers, are trained on CPR.
Yes.
And so they are also trained that they have an obligation, if someone becomes pulseless or unresponsive, to initiate measures such as CPR.
Yes, sir.
And that would be true of, as I said, veteran officers as well, correct?
Correct. It's our policy.
And cadets like Officer Lane received CPR training, correct?
Yes, sir.
And an officer like Mr. Chauvin would have received CPR training on a regular basis.
Yes.
You were asked about the acronym to help identify potential markers of this condition.
Yes.
Would you defer to an emergency room doctor on whether someone is actually experiencing excited delirium?
Absolutely. It's not our place to diagnose that.
I have nothing further, Your Honor.
Anything further? Thank you, officer. You are excused now. Thank you.
That was pretty quick.
Your next witness is available after lunch. What time?
12:30, 12:45.
All right, members of the jury, we're going to take our lunch break, and let's reconvene at 1:15.
Okay, taking a
See you
break.
then.
I do. Barry Vance Broad, Barry Vance Brodd.
Mr. Nelson.
Thank you very much. Good afternoon, Mr. Brown.
Afternoon.
Are you currently employed?
I am.
And where are you so employed?
I'm self-employed as I own a consulting company, BVB and Associates.
And what areas do you consult in?
Police practices and use of force.
All right. Now, did you have a career as a police officer prior to starting your company?
I did.
Can you, for the jury, please describe generally your education that you received in order to become a police officer?
So I have a bachelor's degree in law enforcement from George Mason University, which is in Fairfax, Virginia. I have a California Community College teaching credential from San Francisco State University, and I'm a graduate of the Labor Management Relations program at University of California at Davis.
Okay. And did you serve as a licensed police officer in various capacities?
I did.
When did you start your law enforcement career?
So when I graduated college, I was a seasonal police officer in Ocean City, Maryland. Then I was a deputy sheriff for 6 months with the Arlington County Sheriff's Office in Arlington, Virginia, assigned to the custody division. Then I was hired by the United States Park Police, which is a law enforcement branch of the Department of Interior.
Is that a federal law enforcement agency?
That is a federal law enforcement agency. And I started my career with the Park Police in Washington, D.C., and then I was transferred to San Francisco Field Office in 1977. Then I went on loan to an undercover drug task force in Marin County, California, and then I went to Santa Rosa Police Department in 1982.
And how long were you with the Santa Rosa Police Department?
22 years. I have 29 years total law enforcement experience.
All right. In your capacity as a police officer, do you have any specialized training or experience?
I did.
And what is that?
So I had special assignments as with the Park Police. I was certified by the FBI as a defensive tactics instructor in 1978. I started teaching in the Santa Rosa Public Safety Training Center, and I also taught law enforcement rangers throughout the western region of the National Park Service.
Can you explain what defensive tactics is generally?
So when you look at the topic of use of force, that could include handcuffing, hands-on techniques, baton techniques, handcuffing, pain compliance, and under the use of force umbrella, there's also firearms, but I focused almost entirely on the defensive tactics portion of use of force.
And so you testified that you taught defensive tactics at, you called it the, I believe, the Regional Training Center?
It is a regional academy, but the official name is the Santa Rosa Public Safety Training Center.
Can you describe what that is?
So recruit police officer would attend the training center for their California Post Basic Academy certification. National Park Service Rangers also attended that academy. Corrections officers attend that academy, probation officers, and there's also a EMS component. Firefighters go to that academy, and it also services in-service training.
In-service is training for licensed officers?
Yes.
To meet their continuing education credits?
Yes.
And how long did you teach there?
35 years.
In the use of force, always?
Yes, in addition to other topics.
What were the other topics that you trained?
Weapons laws, interview and interrogation techniques, collision scene preservation, verbal judo, tactical communication skills, or some of the others.
What's verbal judo?
So it is actually, Dr. George Thompson developed the program shortly after the Rodney King incident, thinking that police officers needed better tools to communicate with people. So verbal judo created an outline on how an officer who would make a traffic stop could use verbal skills to overcome a person's potential noncompliance.
Did you also teach or in crowd control, crowd management type issues?
I did. So the topics I taught at the training center was defensive tactics, crowd control, chemical agent, impact weapons, and a variety of the other topics that I just discussed earlier.
Okay. And so you did that for 35 years while you were still actively a peace officer?
So I taught while I was a police officer, and then when I retired in 2004, I continued teaching in the training center for another 9 years.
All right. Do you have have you received any certifications throughout the course of your career?
Several.
Can you describe for the jury some of the certifications that you've held?
I'm going to go ahead and skip through this because this is just building credibility.
So I
I get
have a
it.
post basic. I as a defensive tactics. Can't remember them all.
Okay. Can you describe the nature of your private practice, so to speak, in terms of the use of force?
I take cases from plaintiffs and defendants in civil cases and criminal cases. I do use of force consulting for a variety of public defenders' offices in California, and I was also a member of I was a use of force consultant for the San Francisco District Attorney's Office.
Okay. Have you been involved in prior cases to review the uses of force?
I've had a little bit over 140 cases that I was actively involved in.
Okay. Have you provided testimony in courts throughout the United States?
I have.
Or other arbitrative type civil hearings?
Yes.
Can you tell me the number of times that you've testified in either civil or criminal cases?
So since 2016, I've testified in court, either criminal or civil, both state and federal, 10 times.
And in terms of other types of hearings, depositions, things of that nature, do you testify there as well?
Yes.
Can you describe some of the states where you have previously testified?
Illinois, California, Hawaii, and that's about it.
Have you ever been hired on a case here in Minnesota?
Yes.
And who hired you in that particular case?
Minneapolis City Attorney's Office.
You're being paid for your services, correct?
Yes.
Can you tell the jury your hourly rate and the number of hours you've spent on this case?
I've spent roughly 60 hours. I make $350 an hour for courtroom appearances and $275 an hour for case reviews.
And how much have you, what's the total about you've earned so far?
In this case, $11,400.
Now, simply because you're being paid, does that mean you're going to always, by a particular party, does that mean you're always going to side with that party?
No.
In your career, have you ever been retained by someone and found their use of force to be improper?
Several times.
How is it that you became involved in this particular case?
When this incident first occurred, I reached out to the city attorney's office here in Minneapolis, told them that I had some exposure to the George Floyd incident, and I was offering my services to the Minneapolis City Attorney's Office.
You were ultimately not retained by the city attorney's office or the state, correct?
That's correct.
You then were retained by my office?
Yes.
When you were retained, were you provided with a scope of your engagement?
I was.
Could you explain for the jury the scope of your engagement in this particular
You asked
case?
me to analyze the actions of Derek Chauvin and give opinions regarding his conduct and actions towards Mr. Floyd.
Can you describe the materials that you reviewed in order to analyze this case?
So I received thousands of pages of materials, but I've learned through my experience that I don't need to review materials that really don't have anything to do with the officer or the officer's policies or the use of force policies. So I've pretty much focused my review on the videos, the snapshots of the body-worn cameras that the officers were wearing, miscellaneous statements, the use of force policies, and training records.
So when you say there were some materials that were not relevant to your analysis, can you just kind of give a general example of what that would be?
Horse-mounted patrol responsibilities, vehicle maintenance responsibilities, things of that nature.
Okay. But anything pertaining directly to your analysis, in this case, you did review.
I did review.
Now, based upon your training and experience and your expertise in the use of force matters, your review of the materials that have been provided to you, have you formed opinions in this particular case to a reasonable degree of professional certainty?
I have.
And can you just briefly overview your opinions in this particular case?
I felt that Derek Chauvin was justified and was acting with objective reasonableness, following Minneapolis Police Department policy and current standards of law enforcement in his interactions with Mr. Floyd.
Okay. We've heard a lot over the last couple of weeks about the Graham versus Connor factors. Are you familiar with the Graham versus Connor factors?
I am.
And can you just very briefly provide your definition and your how you look at those factors?
So in my 35 years of teaching, it's not just dealing with tactics, but it's dealing with providing an officer the mindset that what they need to justify to use various tactics that they were trained in. And the standard of Graham versus Connor is, what would a reasonable officer have done in a similar set of circumstances that you're doing?
Now, the Graham versus Connor factors, the first one is the severity of the crime at issue, correct?
Yes.
How do you analyze that Graham versus Connor factor?
So I know in my experience and the experience of officers that I've been in contact with is that the higher risk an arrest may be, like say an armed bank robber. Armed bank robber, you would pull your gun, order them to the ground to take them into custody. Okay, you know their danger, you know their threat level right off the bat. Whereas I can't imagine how many times I've been exposed to personally or seen other officers dealing with a simple thing as a traffic stop or a jaywalking violation or some minor offense, and they end up in a fight for their life just because of the conduct of the individual they're contacting.
Okay. So in terms of the severity of issue, is it always what was the initial response in your or is it something that evolves over time?
Well, the initial response, of course, is important, but it's really how the person you're interacting with as a law enforcement officer responds to you.
Okay. And does that go into the second Graham factor?
It does, the imminent threat.
Right. And can you just explain the imminent threat factor?
So imminent is, from a police officer standpoint, you don't have to wait for it to happen. You just have to have a reasonable fear that somebody's either going to strike you, stab you, shoot you. So you try to plan to deal with the imminent threat, and then you adjust your tactics accordingly based upon how the suspect is reacting to you.
Okay. And the third Graham factor is whether the suspect is actively resisting or attempting to evade, correct?
That's correct.
And can you explain that to the jury?
So again, the level of resistance is commensurate with how they resist you justifies an officer to use a variety of tools on their tool belt. So if a suspect is resisting your efforts to handcuff them and they spin away and try to punch you, an officer doesn't have to go fist on fist with them. The officer's allowed to escalate to use an impact weapon, taser, pepper spray, or other tools.
Now, in terms of, again, the analysis.
So this guy is testifying pretty much in line with what I think.
Analysis of Graham versus Connor, are there other factors or components of that analysis that are relevant?
Yes.
Can you explain some of those?
So as you're reviewing an incident such as this, you have to try to see it through the eyes of the officers on the scene. What factors were they dealing with? What circumstances? What was the suspect doing? What were onlookers doing? Were there environmental hazards? And then try to put yourself in the officer's shoes to see what the decisions they made, were they objectively reasonable or not.
So you would agree with the other people who've testified in this case that the standard involves objective reasonableness? Agreed?
Yes, I do.
Based on the totality of facts and circumstances of this case?
That were present to the officer at the time.
And a view from a reasonable police officer on the scene?
Yes.
And what about hindsight?
So it's easy to sit and judge in an office on an officer's conduct. It's more of a challenge to, again, put yourself in the officer's shoes to try to make an evaluation through what they're feeling, what they're sensing, the fear they have, and then make a determination.
And does that prohibit or preclude a review of a police officer's conduct?
No, not a review, no.
Now, when you approach a use of force case such as this, do you apply a particular methodology in order to analyze the Graham versus Connor factors?
I do.
And can you explain for the jury the methodology that you've used in your previous cases or in your career?
So it's a pretty simple review. So I look at when the officer contacted the individual, did the officer have legal authority for a detention? So let's talk about a traffic stop. If somebody runs a stop sign, police officer has the right to detain you, do a citation. You as the person running the stop sign doesn't have the right to resist the officer. So anything that would evolve from a lawful detention, the officer has certain rights to continue the investigation. Now, A detention detention you need reasonable suspicion for. To make an arrest, you need probable cause. So when I'm looking at use of force cases, I want to make sure that the officer had a lawful right to detain or probable cause to arrest.
And in terms of the lawful right to detain, you used the term, what was that term? Reasonable suspicion?
Reasonable suspicion to detain.
And what constitutes generally reasonable suspicion to detain?
That you see an infraction or a misdemeanor or a felony, and the person that you're going to detain, you have a reasonable suspicion that they've committed an infraction or another crime.
And in terms of probable cause to arrest, how would you define that?
It's pretty much as the statement says, that the person probably committed the crime. And so officers, when they make an arrest, they base it on probable cause.
So in terms of putting
Probable cause is that set of circumstances that would lead a reasonable officer or person to believe that a crime has occurred and the person you're arresting committed or was involved in that crime.
a suspect in handcuffs, is that automatically an arrest?
No,
Can it be a detention?
could be a detention.
So the first, just to make sure I understand your testimony, your first prong of your analysis is to determine whether the officer had justification to detain the suspect, correct?
Yes.
What's the second part of your analysis?
Now, how does the suspect respond to the officer? If it's an arrest situation and the officer tells the suspect to turn around, put your hands behind your back or behind your head, and the suspect complies, and the officer handcuffs the suspect, that's good. If the suspect doesn't comply and they begin to resist, then I look at what level of the resistance did the suspect display to the officer, and then what did the officer do to overcome that resistance.
Now, let's talk briefly in the second prong about the different types of resistance that a suspect could use. Can you describe the levels of resistance that you look for?
So no resistance would be compliance. That's always the goal. The next level would be passive resistance, where you tell the suspect to turn around, put their hands behind their back, and they don't. They're not resisting you. They're just being physically non-compliant, yet without any type of physical strength or any type of maneuvers that they may try to do to prevent you from handcuffing them. So the next level would be active resistance. So I go to put you into a handcuffing position, and you pull your hands away, or you struggle with me. So that's active resistance, where they're using energy to prevent an officer from accomplishing their goal. And then now that same suspect who I want to handcuff pulls away from me, and they swing at me. So that's active aggression. And all those cues are allowing me to start escalating up the ladder of force options I have available to me.
Now, in terms of your experience in various jurisdictions, do use of force policies differ from city to city, state to state?
Very
They
minor.
differ slightly. Usually deadly force policies are fairly consistent. Some agencies have more liberal use of force policies than others. Some agencies now are starting to adopt policies that you can't shoot at a moving vehicle if the only weapon is the vehicle itself. So there's a little bit of a learning curve there for agencies.
Okay. So in terms of your, again, analysis, the first prong being whether there was a justification for the detention, the second prong being the level of resistance exhibited by the suspect, correct?
Yes.
What's the third prong?
What the officer did to overcome that resistance. So if somebody pulls away from you and they're actively resisting, does the officer pull out their baton and strike them in the head? That to me would be excessive.
Okay.
So was the officer's use of force proportionate to the level of resistance demonstrated by the suspect?
Objectively reasonable, correct?
Yes.
All right. So in terms of your three-part analysis, did you apply that analysis to this case?
I did.
In your opinion, was this a use of deadly force?
It was not.
Can you explain that?
Of course not.
So I'll give you an example that I used to teach my academy classes. So officers respond to a domestic violence situation, and the suspect is still there, and he fights with he fights with the officers, and the officers are justified in using a taser to overcome this person's noncompliance. They tase the individual, and the individual falls to the ground, strikes their head, and dies. So that isn't an incident of deadly force. That's an incident of an accidental death. And in my review, I would look to see whether the suspect's resistance to justify the use of the taser was objectively reasonable.
Oh, he should have kept going. I would have kept going on when the suspect dictates the officer's response. If his response is appropriate and the suspect his resistance behavior ends up causing the officer's reaction, and then that reaction ends up causing him to die, doesn't mean the officer wanted or intended or tried to kill him, which is why it doesn't fall in deadly force. The officer acted appropriately. Unfortunately, death occurred.
Can you describe what you would call control techniques?
So control techniques are me putting my hands on you. And it could be, escort position where I put my hand above your elbow and my hand on your wrist. It could be pain compliance techniques, which means I'm doing some joint manipulation on various parts of your body. And if you're doing what I'm asking you to do, it doesn't hurt. If you don't do what I'm asking you to do, I can motivate your compliance through pain compliance, stimulating you with pain.
Now, in terms of your analysis of any case, you, I think you described this a little bit, but did you refer to kind of an increase of level of force to overcome the resistance? How would you describe that?
Police terminology is called one-upmanship. So, police officers don't have to fight fair. They're allowed to overcome your resistance by going up a level or resorting to a different force option to let them accomplish the goal of getting you to comply.
Are officers also required to de-escalate in certain circumstances?
Yes.
And can you describe the process of moving up or down that use of force?
And it's always in response to what a suspect is doing. So if they're fighting, you're fighting back. You're trying to control them. Once they're controlled, you reduce your justified levels of force, yet you're still in control of the person. Anybody you take into custody, you have to maintain control of.
Again, in terms of the use of force, what relevance does possible drug influence have in an analysis?
Has quite a large impact, in my opinion.
How so?
Well, because people under the influence of drugs may not be hearing what you're trying to ask them to do. They may not understand. They may have erratic behavior. They may have they don't feel pain. So techniques you would normally use to make somebody comply, they're not feeling. They may have superhuman strength, or they may have an ability to go from compliant to extreme noncompliance in a heartbeat.
Do you train officers to keep drug-influenced suspects handcuffed?
I do.
Why?
So there's been many instances where handcuffs were removed from a drug-influenced suspect, and as soon as they were removed or some type of first aid measure started to be applied, the person is right back to fighting you, and you're in a fight for your life. So I've trained, and I've been trained, that when you're dealing with drug-influenced persons, they stay handcuffed until they're taken to a medical facility, if that's what the case may be, and they're put in soft restraints on a gurney so they can be treated.
Can you describe the concept of situational awareness?
Yes, I kind of break it down that most people's heads should be on a swivel. If you're walking down a street and you hear somebody running up behind you, your mind thought shouldn't be, well, I wonder if they're going to tackle me, if they're going to rob me. No, you head on a swivel, which means you're cognizant of your awareness, see things that may be a threat or hazard to you, plan for them, and especially as a police officer in uniform stands for certain things. Unfortunately, criminals don't wear uniforms, so officers don't have the luxury of being able to look at somebody and automatically determining if they're going to be a threat or a risk to them or not.
Does the concepts of situational awareness come into or factor into your analysis?
It does.
How so?
So what other threats are present besides the person that we're dealing with? Are there environmental hazards? Is there traffic going by on the street? Are there onlookers? Are there more people starting to focus on your arrest versus just walking down the sidewalk? The officer's exhaustion level. What are other officers doing? Things of that nature.
Is an officer entitled to rely on information he or she receives from dispatch in formulating whether they're going to use force?
In justifying force, I would say no. In preparing to deal with the situation they're being sent to by dispatch, then I would say yes.
Agree.
How does that differ?
So an officer has to take into account what they see on the scene. Dispatchers do the best jobs they can, but they're usually only getting information over the telephone. And the information may be inaccurate, may be false, may be exaggerated. So it's up to the officer on the street to determine what is the best course of action.
Have you reviewed Officer Chauvin's uses of force in this particular case, taking into consideration your analysis as well as some of the concepts we've talked about?
I have.
And let's talk about Mr. Chauvin's uses of force. Where would you say the first use of force that Mr. Chauvin engaged in occurred?
When he joined Officer King and Lane trying to put Mr. Floyd in the backseat of the patrol car.
And in your view of that use of force, what is your perspective on that?
That Mr. Floyd's level of resistance was objectively reasonable for those officers to do the techniques that they were doing. I felt that level of resistance exhibited by Mr. Floyd justified the officers in higher levels use of force that they chose not to select.
And would that be if an officer chooses not to use a higher level of force, is that an element of de-escalation?
Rephrase.
How does an officer's decision to use less force factor into an analysis of de-escalation techniques?
So, an officer sees an incident, feels it has these justification to use these tools to deal with the incident, but just due to the personality or the personal makeup of the officer, they chose not to. They try to expire a lesser technique to see if it'll work, and then if it doesn't work, then they escalate.
Okay. Now, you testified you've watched the videos in this case?
Yes.
Does that include the body-worn cameras of the Minneapolis police officers involved?
It did.
Did it include various bystander videos?
Yes.
And surveillance videos from area stores?
Yes.
And from your perspective, just generally, what are some of the limitations of camera analysis?
So a body camera shows what the camera is pointing at. It doesn't see what an officer may see in their peripheral vision, doesn't show what an officer is actually feeling through their hands or sensing through their levels of awareness. And in low light situations, a body cam shutter responds to lighting situations quicker than the human eye does.
Overruled.
Your last statement.
About the shutter release on the body cam is that it adjusts quicker to lighting situations than the human eye does.
Now, so in terms of the initial uses of force, the officer's efforts to get Mr. Floyd into the car, you felt that they were objectively reasonable.
I did.
Did the use of force then continue after Mr. Floyd was restrained on the ground?
I don't consider a prone control as a use of force.
Let's back up just a
Oh,
second.
I don't know about that one.
Removal or
I don't know about that one now. He doesn't consider a prone use of force. You're keeping a guy on the ground so he doesn't become a threat to you or himself and doesn't run out in traffic and doesn't start fighting. And by keeping him on the ground, you are using force. You're in contact. I disagree with him there. I think he's doing a pretty good job, but I want to hear how he's going to describe that.
Mr. Floyd's getting out of the vehicle, however that was, does that constitute a use of force?
The manhandling or the 3 officers taking Mr. Floyd out of the car and placing him on the ground, yes, that's a use of force.
Was it justified or objectively reasonable in this particular case, according to your opinion?
Absolutely.
Yes.
So when they brought Mr. Floyd to the ground, are you saying you don't consider that to be a use of force?
Up to that point, it was still a use of force, yes.
Once Mr. Floyd is on the ground, in your opinion, does there continue to be some level of resistance by Mr. Floyd?
Yes.
How would you describe that?
Active resistance, he was still struggling against the efforts of the officers. And I saw on one of the body cam videos that Mr. Floyd appeared to kick at Officer Lane.
Is there a reason why officers would take a suspect, actively resisting suspect to the ground?
Yes.
Why?
So officers are trained that anytime you get resistance from a suspect or you're dealing with a high-risk suspect, it's safer for you, the officer, and for the suspect to put him on the ground in a prone position face down for a variety of reasons, some of which are it makes the suspect's mobility diminished. They can't get up and run as quick. It takes away some of the use of their hands, so they can't grab you without turning their body, which would give an officer time to react. It limits what they can do with their feet. They can still kick, but they don't have as much mobility or power that they would if they were standing.
Now, in terms of this particular case, you understand Mr. Floyd was handcuffed at this point.
Yes.
Does the fact that Mr. Floyd was handcuffed somehow come into the analysis as to whether or not to put him into a prone position?
No, any resistor, handcuffed or not, should go to the ground into a prone control position.
And can you describe generally what you mean as a prone control position?
So it's where the suspect either, in this case, handcuffs are behind the back, placed on their stomach and their chest, and officers are in a position to apply body weight to keep the suspect on the ground and to keep them further immobilized.
Is that a normal
Would it
technique
be
that's
common
taught?
practice in that situation to employ an MRT or hobble restraint?
You could.
What would be the factors to determine whether or not an officer
Depends on
would
the
employ
agency
such a
policy.
So can the officers control the person's legs? Does the person need to have their legs controlled in the situation they did? And could Officer Lane be successful in trying to control the legs? So it was those part of the force option selections that they had to make.
In terms of your familiar officers in this particular case, considered the use of the MRT,
They did.
and they ultimately decided against it, correct?
That's correct.
How does that factor into, or the decision to not employ the MRT factor into the analysis?
That it's one of those situations where they were justified in the maximum restraint and chose not to. So why they had that decision making, I'm not sure. Maybe, Mr. Floyd had made comments about being claustrophobic, and I know in the teaching I've done with leg restraints, if you leg restrain somebody in training or on the street that is claustrophobic, it creates a reaction.
How does the fact that EMS had been summoned factor into your analysis?
That I think what I've read in the materials is that there was a fire station literally seconds, if not a minute to a minute and a half away. So if you have somebody that's under control and is in need of medical attention, and EMS, who have the training and equipment to do a lot better job than police officers can do, that would be relevant to me that, okay, we call them, they're going to be here instantaneously. Let's just kind of stabilize the situation and wait for the professionals to show up.
Would a reasonable police officer, based on the reasonable police officer standard, is that a factor that comes into the analysis, that the EMS response time?
Yes.
What about a suspect, keeping a suspect in the prone position who is potentially drug impaired? Are there safety reasons to do that?
Again, so as I discussed earlier, potential erratic behavior, going from compliant to non-compliant, not feeling any pain, potentially having superhuman strength, and it's just safer for the officer and for the suspect to keep them in that prone control.
Why would it be safer for the suspect to keep him in that
Because
prone
he can
control?
run into
Because if they were to
traffic.
get up and run, handcuffed, trip and fall, sustain facial injuries, other injuries on the ground, their mobility is reduced, their ability to move is reduced, and the ability to hurt themselves is reduced.
What if they became sick, for example?
Prone control, instead of having somebody lay on their back where they could aspirate on vomit, prone control, their face is down, airway is clear. If they vomit, it's not going to go down their trachea or down their throat.
Now, you've obviously, in addition to watching the cameras, you heard what Mr. Floyd was saying at that time, right?
Yes.
And how do officers take into account an analysis of words versus conduct?
So you hear what the suspect is saying. So if I want Mr. Floyd to get in the back of the car, and he's saying, I will, but he's not. And I'm trying to force him in, he says, I will, but he's not. Then his actions are telling me he's not getting in the car regardless of what he's saying.
What about as Mr. Floyd was going into the car and there was this act of aggression, as you defined it, and Mr. Floyd at that point was saying he couldn't breathe, but he continued to say that later. How did the words he was saying initially comply or comport with his actions in that instant?
You know, I have advanced first aid. I certainly don't have medical degrees, but I was always trained and feel it's a reasonable assumption that if somebody's, I'm choking, well, you're not choking because you can breathe. If somebody's saying they can't breathe, it appears to me they're taking full breaths and they're shouting to me, the layperson, they can breathe.
Is that a common misunderstanding within the policing community?
I believe it is, yes.
Objection, lack of foundation, strike.
Overruled.
So in terms of a reasonable police officer
Man, the prosecution sure is objecting. They've objected more on this witness than the defense objected during the whole trial.
standard again, is a reasonable police officer who has used force in an instant, can they consider that in prolonging a detention or a prone control of a suspect?
So if the officer was justified in using the prone control, and now the suspect is on the ground in a prone control, the maintaining of the prone control to me is not a use of force.
Why is it not a use of force?
That's a control technique. Without it, it doesn't hurt. You've put the suspect in a position where it's safe for you, the officer, safe for them, the suspect, and you're using minimal effort to keep them on the ground.
Now, you're familiar with the concept of positional asphyxia, correct?
I am.
Can you describe for the jury what you train and have been trained that are the dangers of positional asphyxia?
So the training I received is that a target person for positional asphyxia would be somebody who is very obese. And now you take that obese person and you handcuff them behind their back, really pulling their shoulders back, really constricting their rib cage. And if you put them face down on the ground, that would be the training model for somebody who could be prone to positional asphyxia. And when I was first in law enforcement, and the training I initially did regarding leg restraints, is that you used to hobble a person's ankles, tie the ankles to the handcuffs, and then put the person face down, and that created even more pressure on the person's sternum and rib cage and reduced their ability to breathe. So that technique was modified to address the positional asphyxia issues.
You would agree that the Minneapolis Police Department trains officers to place people in a recovery position, correct?
Yes.
And you would agree that is based out of concerns of positional asphyxia, agreed?
Yes.
Now, are there situations where a reasonable police officer would not put a person in the prone position into the recovery position?
Yes.
Can you describe what those may be?
So in this situation, there was space limitations. Mr. Floyd was butted up against the tire of the patrol car. There was traffic still driving down the street. There were crowd issues that took the attention of the officers. Mr. Floyd was still somewhat resisting, so I think those were relatively valid reasons to keep him in the prone.
Now, in terms of your training, again, that you have been trained and trained other officers in the use of crowd control or crowd control issues, right?
Yes.
How in law enforcement is a crowd defined?
So a crowd is just like if you look at a football stadium. So it's a group of people gathered together for a common purpose. So a crowd, by definition, isn't unlawful. And actually, the law enforcement definition is two or more people constitute a crowd. So because it's not unlawful, it doesn't mean that it doesn't become a consideration for the officers.
Okay. Can you explain in your analysis how you think the crowd or this group of people that had gathered around and were watching affected the officers in their use of force?
So we kind of go back to the situational awareness issue, is that yes, the officers are dealing with Mr. Floyd, but there's also other factors for them to consider. And in this case, the crowd started to grow in size, started to become more vocal. So now officers are always trained to deal with, right, so what threat is the biggest threat? Is it the suspect on the ground in front of me in handcuffs that we have relatively controlled? Or is it the unknown threat posed by the crowd that could go from verbal to trying to interfere with my arrest process in a matter of seconds?
Oh, that's a good explanation. I mean, this guy seems pretty legit. We'll see how he handles. Remember, when they handle the other side is where we'll see if he's really biased or if he really believes what he's saying and he defends it.
Did you factor that into your analysis of this case?
I did.
How so?
I could see that Officer Chauvin's focus started to move from Mr. Floyd to the crowd. To one point, I think Officer Chauvin felt threatened enough that he withdrew his pepper spray canister and gave verbal commands to the crowd to stay back. So now he's dealing with the bigger threat.
So just to kind of wrap up, could you summarize the final opinions that you have made in this case?
I felt that Officer Chauvin's interactions with Mr. Floyd were following his training, following current practices in policing, and were objectively reasonable.
Thank you. I have no further questions.
Wow, I figured he would go longer than that on him. This guy's pretty good. So he went pretty good. He's going to let the prosecution chew him up, and then he's going to come back. So I'm going to make this another video on the cross for the prosecution.